On the left, Bruce Long from Carter and Associates. And again, Bruce has very carefully given me instructions on how to introduce him, not as a criminal lawyer, but rather as a lawyer who specializes in criminal law. And yeah, semantics, yeah. And I'm really pleased that he's here because he's been involved in actual litigation with churches on abuse cases. And Bruce is usually pretty blunt and upfront about saying things, and it's something I really appreciate about him. Next is Detective Sergeant Joanne Rudnik from, I guess it's Toronto Police Services, and you were involved in the sexual assault unit for 7 years? Yes. Okay, and I'm really pleased that she could make it here today. Next is Melodie Bissell, who was one of the authors of Original Plan to Protect, and is basically overseeing Winning Kids, which an organization that has a display out in the foyer, has just recently, this past August, introduced version number 3, Plan to Protect 3, which we highly, highly recommend. And in addition to exclusively having the rights to distribute Plan to Protect, also provides consulting services for implementing, training, and helping organizations with their abuse prevention plans. Anything else to add to that? Is that good? Next we have David Amy from Amy, Appleby, and Brennen. And David is a civil lawyer, not a lawyer who specializes in criminal law. And he's a very nice guy, he tells me. And he's very civil. And David's been involved in working with Christian charities for many, many years, involved in issues of incorporation and in helping organizations to prioritize and establish their abuse prevention plans. He's also been very gracious in helping us and serving on an advisory committee in terms of helping to establish our 7-point checklist in the first place. And we really appreciate his being here. And last but not least is Judi Smeltzer, who is the underwriter at our company, Robertson Hall. Many of you maybe have talked to Judi. One of her specialties is in abuse prevention procedures, and she often sees your abuse prevention plan or your declarations come in, approves them, or comes back to you and says, no, this is needed to qualify. So she's going to be speaking from an insurance perspective. And so I've got a list of questions. We've got lots of good questions. I'll try to get through as many as possible. But I'll start. I'm never quite sure. The short questions, are they the tough questions or the easy questions? I don't know. First question is there a policy of police checking minors? Are they not protected by the Young Offenders Act? Not sure exactly who to ask this question to first. I don't know. Yeah, that's what I thought. No one wants to take responsibility. Do you have the mic up there? Sorry, it should be right there.
Can I hear the question once more?
Absolutely. Is there a policy of police checking minors? Are they not protected by the Young Offenders Act? So, I don't know if you want to, whoever wants to handle that question. Melodie, do you want to maybe take this one? That would probably be, yeah.
Youth are protected under the Youth Offenders Act. They can get their own criminal record check directly from the police station. So they cannot get a police check done through an organization like Back Check or Winning Kids. You will get a police record check, but it will come back clear. And that just means that they are cleared from any convictions as an adult. It does not mean that they are cleared from convictions as a youth under the Young Offenders Act. So you have to be aware of that. A third party cannot receive a criminal record on a young person with convictions under the Young Offenders Act. It has to go they have to go directly to the police station, often with their parents, get permission to receive that police record check, and then submit it to the ministry leader. That should not discourage you from getting a criminal record check on young people done, because there are convictions and they can get it directly from the police station. You want to add to that?
Thank you. question here is, what if a person, child or youth, speaks to a leader at a church or charity about abuse in their home, but asks to keep it confidential?
You simply cannot keep it confidential. They're under responsibility to report it directly, immediately to CAS. No ifs, ands, or buts.
I'd just like to add one of the things that Ken mentioned in his presentation is if that person wanted to go to the pastor or senior pastor and that senior pastor reported, that's fine. But as a senior pastor, make sure that you have that person available to be interviewed by the police, because that's the person that we're going to want to speak to. That disclosure, that first disclosure is very important. So we're going to need access to that person, even though the senior pastor made the telephone call.
Ken, if I could just add to that, the section in the Child and Family Services Act says every person, including a volunteer, who believes on reasonable grounds that a child is or may be in need of protection must, it's not may, it's must report promptly the belief and the information upon which it's based to the local family and children's services. And adding to your comments, I think if the pastor is informed by a volunteer of that suspicion, as the individual, I would want to know for sure that the pastor's actually made the report. Otherwise, you're caught by this particular provision. It's your responsibility to do the report.
The other question here is, police checks are only as good as the day they're done. And continue on, why is recommended frequency for police checks 3 years? And I'm just going to jump in and answer this question because it is an insurance question, and to some degree it's an arbitrary time period, and I'll admit that. It's a standard that we've set. The problem is we don't really have any clear indications from legal precedent. What do the courts consider as a reasonable frequency for checking? You know, is it every 6 months? Is it every year? Is it 5 years? Got all kinds of different suggestions or ideas. Essentially, we kind of sawed off the period of time in the middle, and if we get direction on what is reasonable, we'll certainly set that as our standard. But right now the standard is a check every 3 years. And part of the problem in this too is that the nature of the position could also dictate how frequently you're checking, you know, how intimate is the position this person has with you. I don't know if you have any comments to add, but from an insurance perspective, that's a standard that we've set, and it could be subject to change, but that's how we're going forward.
Can I just add that it also is how often you see the person. If you're at camp and you don't see that person for a whole year, you may want to have a criminal record check done on an annual basis. But if you see that person every Sunday, you'll have a good idea if they disappear for 3 months to 6 months or 2 years.
I was just going to say, Ken, I don't see any reason you can't bring it down a bit to 2 years. I think a lot can happen in 3 years. And isn't there a vacuum in space there that you're not going to know anything? So I don't understand. It doesn't take that much trouble, it doesn't take that much money. Why don't we bring it down to 2 years? And maybe my question is to you.
To me, yeah. And you know, we've had this a very lively debate about this, everywhere from 1 year to 5 years. So you probably didn't want to hear that answer though, right? Hey, I'm looking good now. But it's a good point. Thank you very much. I'm going to direct this one to Judi. This particular one is short and sweet. Retreat center. We have a housekeeper. Do we police check her?
Yes, you would. There could be opportunity for that housekeeper just to have access to kids. Again, the whole thing Ken was saying about a hallway, a cabin, a door. You know, if you have the police check done, then you can say you've done your due diligence. You know for sure that the people that are around your area are safe. You know, and you've done what you can do.
Because it is a residence, and you think about it as known to the kids at the camp. I mean, this is a person they're probably going to think is a person deserving of trust. Right?
I think the purpose of these criminal records checks and all the screening that we do is to protect the children. And we can't lose sight of the fact that that's the primary reason we're doing this, not to get insurance coverage, not to preserve our ministry, it's to protect the kids. And if there's a cost associated with that, then we have to assume that responsibility of paying those costs. Because if the child is injured and unfortunately had churches where there's been allegations against pastors, the damage that it does is so extensive, the cost pales in comparison.
This could be a question, I think, for Joanne. Reporting suspected abuse, and we get this question a lot too. Do we call police or do we call CAS?
Either one. We in Toronto do joint investigations with the Children's Aid Society, so whether or not you call the police directly or whether you call the CAS, the important thing is that the matter will be investigated. I'll caution you that if you do not have training to interview children, then don't interview children. If you're a pastor or minister, that's your vocation. It's important to let us interview. So the disclosure may come in, a child may utter something, you make note of it, you support the person, the worker that perhaps brought it to your attention, and then you call CAS or us.
Because if you interview the child, you're going to end up as a witness in the witness box somewhere down the road, and that doesn't do a whole lot to reconcile you to the offender or vice versa. Excellent advice.
It's a good question. I could answer this question, but I'm actually thinking I'm going to get David to answer this one, because I'm curious.
Is this a trick?
We'll see. Let's say that we have physical abuse take place today at our church. We currently have $2 million liability coverage. The abuse claim, though, is not brought forward till 2028, 20 years from now. The liability coverage in 2028, say, is $10 million or whatever it is. Does the claim go back to 2008 values? In other words, $2 million. And this is the whole issue of judicial inflation and damage awards as they increase. I mean, I can answer the question, but why don't you answer the question?
I guess I'd rather have you answer the question, so it's right.
From an insurance standpoint, and again, if you've got some different thoughts on this, but the problem is that you're really insuring for something literally that could be brought forward many, many years into the future. So actually the limit you are picking now, maybe the limit you're stuck with a long ways into the future, which is another good reason to maximize the limits of coverage that you have. Because you may be paying a future claim that's awarded, and courts are not going to award in 2008 dollars. They're awarding based on what the standard is at that point in time.
No, and your premiums are based on those values as well, and I think that would probably be a stretch to suggest that inflated dollar amounts will be the basis upon which the judgments awarded. So.
This is one that I'm probably going to answer myself, but if there are some comments, I think it would be interesting too from the panel members. I wasn't sure what kind of question I was reading here at first, but it is a really good one. Will the goalposts keep changing in terms of what is needed to qualify for abuse insurance? And I think it's nice to have a sports analogy in this. That's good. It really appeals to me. But in other words, these are the standards, the 7-point checklist. Are they going to keep changing? I don't know. I don't know. They've been the same for 3 years now. Do statutory regulations change? Did precedent change? Do social trends change? Yeah. Do I foresee there's going to be changes, or at least significant changes? Not really. Could, but I can't make any guarantees. But we're going to basically be setting standards and keeping those standards based on what courts are expecting, what laws are expecting, what society is expecting. I don't have any control over that. Insurance, you see, is not the primary driver here. It's secondary. It's responding to things that are going on in society, in courts and in society. I don't know if you have any comments.
Can I just mention that we first wrote Plan to Protect in 1996, and it had less than 40 pages. In 2000, we added a number of pages. We went up to about 100 pages, and the 2007 version of Plan to Protect is now 250 pages. So there's much newer content in this version. So if you are using an older version of Plan to Protect, there are things such as PIPEDA, lockdown. Even in the last 8 months, we've added a lockdown policy, which was not there last August. So our newest version of Plan to Protect does have a lockdown policy. And even in the last 3-4 weeks, we've heard of so many schools that have gone into lockdown. We don't like to think that happening in a church situation, but if there is a shooter in the community, you would want your church to go into lockdown.